Our guest today is Swapnil Tripathi. He's a lawyer by profession and is currently doing his DPhil, that's Doctorate of Philosophy from the University of Oxford, as a Gopal Subramanian scholar. He takes a keen interest in constitutional law and legal history, which is why it makes him this makes him a really apt guest for today. And he has written in many forums like Live Law, Bar and Bench, Quint, First Post, Leaflet, and the list goes on. He's also author of a blog called The Basic Structure, where he simplifies Indian constitutional law and developments for common man's understanding. Now, the topic today that we're discussing today is the Uniform Civil Code. And this is a subject that has been on and off discussed since independence, but has never been a definitive law that has mandated passing of such a code. So recently, the Law Commission put out a circular that they're relooking whether a uniform civil code can be implemented for India, and has invited people to give their opinion and feedback. And to help people understand this concept a little bit better and to be able to share more detailed and nuanced feedback, we're speaking to Swapnil today to understand what a uniform civil code truly is. So thank you so much for joining us, Swapnil.
No, thank you so much for having me.
I'm just going to dive straight into the question. First one that we have is that most people understand UCC to be a set of laws for all citizens, common laws for all citizens. Could you please elaborate a little bit more on what this actually covers and what would change if a UCC is to be implemented in India?
Sure. Before I do that, let me first clarify the current position of law in India with respect to issues of marriage, adoption, succession, etc. So it's split in three categories. One is statutory law, which is the law that is passed by the parliament. Second is personal law, which are broadly religious practices that a person belonging to a certain religion has to follow. And third is something called the customary law, which is a practice that has been followed by a community for a certain period of time. And now that has become the governing law for that community. So we have three separate stratas that exist today. Now, a good example for customary law, because that's something people are usually not aware of, is the constitutionally protected practices, let's say in the Northeast, where every community has their own practice of how a marriage is supposed to happen, how succession happens, etc. Now, before delving into what the UCC is, it's important to understand that codification is very important in the first place. So Uniform Civil Code stands for, the code is one of the words in it. Now, codification is very important even before we get a Uniform Civil Code, is because that there is a very regressive decision of the Bombay High Court that was delivered in the year 1951 called Narasu versus the state of Bombay. Now, what this decision effectively said was that the court held that personal laws, the term personal laws and the laws therein, are not included within the definition of laws in force under Article 13.
Okay.
And hence, they cannot be tested for violating fundamental rights. So what it means is, in effect, personal laws are immune from any challenge for violating the Constitution. They are beyond the purview of the Constitution, and nobody can challenge it for violating the right to equality or freedom from discrimination on grounds of sex. And the only way this personal law can be challenged if it has been codified. So let's say there is a practice followed by a particular religion, which is patently discriminatory towards women, but that practice has never been codified into law, statutory law. Now, you and I have no option to challenge it because it's personal law and it's beyond the ambit of courts to see whether it violates or not. But if the government codifies that practice, puts it in a statute, then automatically you're supposed to test it under the Constitution.
Okay.
That's why codification as an exercise is very important, to be able to challenge any and every personal law that is out there. Now, coming to what is UCC. So UCC is ideally understood as a common code that governs aspects of marriage, divorce, succession, adoption for all citizens, irrespective of their religion or the community they come from. However, the issue is not as simple, because since the Constitution's inception, we have had no clarity over what the Uniform Civil Code means. Because if you look at the debates in the Constituent Assembly, when Article 44, which is right now a directive principle of state policy, which means it's an unenforceable right, when this provision was debated in the Assembly, the discussion was focused more on the need and acceptance of a UCC rather than what its content would be. So people who were speaking in favor of a UCC were people like Dr. B.R. Ambedkar or K.M. Munshi or Alladhi Krishnaswamy Iyer. All of them were trying to convince particularly the minorities, that if we adopt a UCC, it will be a progressive code and not an imposition in your respective personal law. So a lot of the debates talk about the need for the UCC rather than what the UCC would be. And there were many members who raised objections stating that personal laws are something that should not be tampered with. And at that time, K.M. Munshi, who was a very strong proponent of the UCC, had said that personal laws are something that are moving towards codification globally. So even amongst global nations, Islamic nations, progressive Islamic nations, codification is something that has happened. But they never discussed what the content would be. The person who claimed closest to it was Dr. Ambedkar, when during one of his speeches, he said that we will adopt the best suitable practices from all religions, which could be interpreted to mean that we will go through every possible religion in India, every possible personal law in India, and then we will decide what is suitable for India, and those practices would be adopted. And this is the closest we got to understanding what the UCC is. Now, even today, since the Law Commission has come out with this notice, and even the Prime Minister has issued a statement in one of the election rallies, everybody has been discussing the UCC in India without really knowing what the UCC is, because there is no code, there is no draft, there is nothing. So it's all very speculative at this stage. So everything we discuss here is very speculative because we don't know what the Law Commission is going to do. However, if I had to speculate, I could think of UCC being adopted in the following ways. First would be we adopt the version that the 2018 Law Commission had given. So in 2018, a consultation paper was issued by the then Law Commission under Justice Chauhan. And that had said that instead of adopting a common code, what we will do is we will study the personal laws of every religion, and then we will codify all of it and recommend amendments to those laws, which are gender just and do not discriminate against women or any other community. And he had said, in addition to that, we will have a list of common rules that are applicable to everybody. So if I had to give you an example that, let's say we look at all different personal laws in India, we identify which of the ones are problematic, and that's their respective code. But along with it, what we would do is there are certain principles like consensus on the age of marriage. There will be a uniform age of marriage. The grounds of divorce would be common. Registration of marriage would be mandatory. Or recognizing that if one of the spouses is a homemaker and they're not on an officially full-time job, you are identifying and recognizing even their contribution in family income by stating that if a divorce happens or in those cases, the property that is acquired after the marriage by either spouses will be treated accordingly. So these were common principles that they said will apply to everybody, but rest personal laws stay as they are. So that is one approach that can be followed. The other is the Ambedkar approach of best practice method. So what it means is that the commission and the government will sit through all existing statute, personal laws and customs and cull out the good progressive practices that are there and then make a code out of it.
Okay.
Now, the problem with this approach is that India is a very diverse country and there are several personal laws and some of them are very contradictory. I mean, to give you an example, under Hindu law, a marriage is considered to be a sacrament, which is not to be broken. But under Muslim law, a marriage is considered as a contract, which are essentially contradictory. In this situation, the question arises, how will the government or the Law Commission make a choice? Because when you choose one, you're saying one is better than the other, which is sometimes not possible because you're making a judgment call. So that's the biggest problem with the best practices method, that there are going to be a lot of contradictions. Third is something called a progressive vision document, which was actually submitted when the 2018 Law Commission report came out. There were a couple of individuals who submitted a code to them along with the support of Mr. Soli Sarabji. And what this code basically spoke about, it said that we will divest our civil code of religion altogether. We will not enter into the question of religion altogether. Instead, what we will do is we will come up with the uniform principles of who can marry, what are the principles of marriage, how registration is going to happen, how succession will happen. And none of it will have to do with religion at all. And they even recognized same-sex marriages in this category. They said the concept of family as envisaged under our religious laws is very archaic. It does not take into account subsequent developments that have happened, how the society has evolved. So we will come up with uniform principles, progressive principles, and that will form a uniform civil code because we are not going into religion. There are going to be no inconsistencies, and it's going to be a uniform practice that we will adopt. And this was submitted to the Law Commission then. So there are multiple ways in which this UCC can come out. And these three are the best possible scenarios that we can think of. Of course, there are concerns of one religion's law dominating the entire narrative, which is something I'm hoping doesn't happen because consistently, historically, the position that has been pushed by government, irrespective of whose government it is that we'll go by the best principles of everyone. But these are the three possible ways in which I think it can be done.
Lovely. And one of the things that comes to my mind when you spoke of the three different approaches was that for it to be implemented in a manner that's accepted by all, I think the first phase or the first phase of implementation would have to be somewhat voluntary, I guess, because you wouldn't have to
Uh,
be you
mhm.
wouldn't
No,
be
please continue.
imposing it right away, right? Because what my second question was, and also you've touched upon already a little bit, was the religious freedom that the Constitution offers. So for it to balance out with the your right to religion as well as your ability to, like, state's ability to introduce a uniform civil code, you'll have to keep it voluntary. And I think Ambedkar had also spoken about the voluntary nature of such a code, right?
Exactly.
Can you talk a little bit
Exactly.
more
So,
on that?
yeah, so Dr. Ambedkar had, because there was so much heated discussion on the possibility of a uniform civil code. So he had said that right now it seems that the society is not ready for a uniform civil code. And maybe to gain that trust, voluntary UCC is something that might be a good idea. Because right now we are attempting to undergo something very radical, and religion is something that is very central to identities in India, which is why you can't, if you tamper with them or mandatorily tell them they can't do a certain thing. What being voluntary is an approach that can be adopted, that you test waters, and if the code is actually progressive, slowly the society will get there and will start opting for a voluntary code. The only caveat with that is that if you do make it voluntary, there might be certain practices that are still discriminatory. And given how patriarchy works in a society,
Mm-hmm.
how other factors work in a society, people might not be willing to, might not have the actual choice to opt for that voluntary code because the family doesn't allow them, the society doesn't allow them. So that's a delicate balance that has to be looked into. So a good step that takes care of that is if you have reformation of the personal laws in the first place, and every community does it without discrimination altogether. They agree to do it. And if there are blatant practices, because there is no religion in India that does not have a discriminatory practice. That should be clear at the outset. There is a lot of hyperbole and claims made that, oh, one is better, the other is better. Every has some problem with the other. So that's why a good first step might be to identify those practices and have a consensus that if something is discriminatory, it has to go. If that is a success, then you have a code that's applicable to everybody. And I think then it would be a better exercise to do because it will ensure that people have no choice but to let go of a discriminatory law.
That
Yeah.
makes sense. And I think there's also a lot of room to see past examples, like how Special Marriages Act came in and has, even though it has certain inherent issues that are being highlighted in terms of allowing same-sex marriages and other issues around it, there have been like successful examples of interreligious marriages being registered under Special Marriage Act. So that would be a good example to use to uh, basically show that something like a UCC, like one of the three approaches that you identified, could be possibly used.
Exactly.
Yeah.
Yeah.
And it does, like, and does make sense, because I think I read a while ago that the most number of interreligious marriages or uh, interreligious marriages happen in India, in the world. So
And the most interesting thing about it is that while I was reading the debates of the Special Marriage Act, all of these reforms, which to us seem like a very usual thing in today's time, there was such significant opposition whenever these reforms were being brought in. People were just not willing to let go of their caste hierarchies and say, how can you allow intercaste marriages? And like Prime Minister Nehru at that time had faced so much opposition, and of course that's something I will touch in when we speak about the gender question.
mm-hmm.
But difficult laws which are trying to do good always face opposition. But it's the will to do good which really matters, and the intention should be very clear that you're not pretending to do good. You're actually wanting to do good in the first place.
That makes so
And
much
Special Marriage
sense.
Act is a very good example of that. It's a very good example of that.
That's really nice, because I kind of like the fact that there is sort of a case study to talk about how you can get in a structure that benefits all,
Yeah.
and ensure that um, every religion has equal representation at the same time in terms of getting a code that favors all.
Yeah.
That's lovely. I also want to touch upon the issue of distribution of property, because as we understand that there are certain religions in India that govern how property has to be distributed within family members, either based on current like businesses that they register, or even in matters of inheriting property. So would that also be included under UCC, or it's only in terms of marriage, divorce, and marriages
I mean,
and divorces?
It depends. So for ideally it should, because it's a very important part of like how you understand personal law conventionally is that it includes not just marriage, but it also includes marriage, adoption, succession is a very important part, and so is divorce. Conventionally, that is how we've understood personal laws generally. And even when, let's say, the Hindu Code Bill came about, it did take into account how succession would happen. The Hindu Succession Act did deal with it. The Indian Succession Act dealt with it. Multiple legislations deal with it. So it'll be surprising if they don't touch upon succession. But the problem is that because they are at the end of the day religious laws, every community has certain principles that that guide how succession is happening in the first place. So, for instance, when we talk about Muslim personal law, we have this rule that you can only bequeath 1/3 of the property through a will. You can't bequeath more than that. Now, historically, the reason behind that is that the makers at the time of the wanted heirs to always be taken care of. They did not want you to be able to will out more because they wanted heirs to be taken care of. Similarly, when they have another rule which says that a sister or a daughter only gets half the share of the brother or the son. Now, these are laws which are very central to the society at the time, which at that time did not treat women equally. Now, if we were to retain something like this today, it's quite bizarre because our constitution talks about equality and no discrimination on grounds of sex. Similarly, there are provisions in Parsi law, Christian law, Hindu law. Every law has some provision that is patently discriminatory in terms of succession. So it would be quite surprising to not touch it. If you end up codifying a practice and it's tested on the angle of Articles 14 and 51, they're bound to get challenged. And that's what the Law Commission had also recommended in its 2018 report, that it said that these practices don't stand in today's time. And you need to be able to divest religion from personal laws because it's not like our laws around us are not uniform. It's uniform. Contract is uniform. Everything else, we have a uniform law around us. It's just something that hasn't been touched upon. So I think it would be quite surprising if they don't touch upon succession per se, because succession is so central to every other aspect you're dealing with. It's central to adoption. So for instance, if I change the law on adoption and I'm able to adopt a certain individual as my son or daughter, then that also affects my succession, because if my property is to go through them, then it will affect adoption. Who I marry, whether that marriage is recognized in my custody. So Parsis are very strict about marrying within the community. If I change the law on marriage, how will it affect my succession? Because succession only happens to Parsi. So it's like Lon Fuller gives this very beautiful example of a spider web phenomenon, where if you pull one string, there are 100 changes that are happening on different strings. So it's like the personal law is an issue like that you can't just touch 3 and leave 1 out, because it will have repercussions on the 4th as well. So they're bound to touch it and come up with a concrete solution when they do it.
Lovely. I think it's going to be interesting to see what the Law Commission comes up with in terms of looking at how property is to be distributed and divided into. I also want to talk about a little bit about what courts have said on UCC, and I know you touched upon the Bombay High Court judgment that spoke of not getting into laws that are not codified. Has there been any other ruling, not just like in Supreme Court wise, but also in High Courts in terms of how they've looked at UCC, or has this been covered in any of the cases since the Bombay High Court judgment?
They have actually. UCC has always been a hot topic in India. Courts have time and again called on the parliament to enact a code because it's a directive principle and it's totally incumbent on the parliament when it does it. So for instance, in the famous Shah Bano case that we all know, which dealt with maintenance of a divorced woman under Muslim personal law, and finally the court said that she is entitled to maintenance under section 125 of CRPC. In that case also, Chief Justice Chandrachud had called for enacting a UCC, which he said will help national integration and removing conflicting laws. Because at that time, maintenance differed from religion to religion. Religion A might allow it, but under Muslim personal law, it was not allowed after a certain period. So similarly, that was one case. Then in another case of Sarla Mudgal, which is very famous for being the case where a Hindu man was married, got converted to Islam, and then underwent a second marriage. In that case, also Justice Singh had called for divesting religion and personal law, and his brother Sahai, Justice Sahai, had said that we can only bring such a law when the society is ready. And there have been similar observations passed in another case of ABC versus State of Delhi, where the court was dealing with the issue of guardianship of an unmarried, of a single Christian woman. So you'll see that courts have consistently called for UCC, but they've only done it in situations where they were dealing with a discriminatory law. which had to be upheld because it was a personal law or it was something that was allowed in the religion, because they also had no choice but to uphold it. So that's indicative of the fact that courts have also been urging towards the UCC in cases where they've seen discriminatory practices happening, where they've seen a lot of confusion amongst community on what the law is. So in all those cases, they have pushed for recognizing UCC in the first place. And you'll notice people often wonder why this change has happened between the 2018 Law Commission report and the now Law Commission invitation. That's there because in the middle, there have been two more High Court judgments that have called for UCC. There is a Kerala High Court judgment and there is a Delhi High Court judgment, which shows that even the courts have been urging towards it, and that's a reform that they're really pushing for. But a survey of the decision shows that it's a voice that has only arisen when we've been dealing with discriminatory laws. So I think that's a good takeaway to take from these decisions, that whenever a discriminatory law comes and the court feels very helpless on what to do, it feels if we had a codified law, codified UCC, they would have served better interests. Yeah.
That's quite interesting to know. And you also spoke of the 2018 Law Commission report that spoke of, and in that consultation paper, it went into talking about how at that time the a UCC was not desirable, and if an activity like this had to be done, you had to gauge into what the people thought about UCC, and only after there was public interest would something like this could be reconsidered, right? And one of the other things that they spoke of was advocating for gender equality laws in existing family laws. So how does the UCC help in promoting gender equality laws and women's rights?
First of all, to clarify, I think often people mistake what the 2018 Law Commission said.
Okay.
It said that you can't develop a UCC without active consultation.
Okay.
So that's a very important part about the report, because they have issued a consultation paper because the consensus hadn't been achieved. So a way to look at it is that the new Law Commission is trying to get that consultation. But of course, I have a problem in which the way they're doing it, and that's a question I'm sure we'll touch upon, about how the consensus should happen. But coming to the gender equality bit, it's a very interesting thing, because I think gender equality and women's right has been very central to the entire codification project. So since you did say that I do love writing about legal history, I'm going to keep putting some legal history in all my answers. So starting from our demands of a UCC, a Hindu court bill, to the present ongoing debate, the justification which is often or always offered by incumbent governments is gender equality and gender justice. However, one must be very careful that the debate is not a mere rhetoric, and in fact, meaningful discussion is happening. So what the 2018 report did, and why I think it is a very good start, is because it looked at all the personal laws from a lens of gender equality, and everything it identified was problematic. It said this is problematic, this should change, this is problematic, this should change, which I think was a very good exercise. To give you some examples, for instance, in Hindu Minor and Guardianship, Minority and Guardianship Act, it said that the law says that the natural guardian can be a father or a mother. But often what courts do is, because it says father or mother, they end up giving the preference to the first one. That's why what we should do is, in matter of semantics, we should use the words parents. Similarly, for self-acquired property of Hindu female, if she dies, the preference is given to the heirs of the husband, even over her parents and her siblings. So they recommended that this was discriminatory. Similarly, for Muslims, the mother should be treated as a natural guardian in addition to the father as well, which was not the case. And for Parsis, they said that if a woman marries outside her community, she should still retain her identity as a Parsi, because the law says otherwise. So there were such provisions that they had culled out, and it's a 180-page report, which it's a beautiful reading because it lists out all the problems that exist with the current law, which I think was a very good first step, because when we understand personal laws, we think that we only think of certain practices which are discriminatory in the mainstream. But there are many other practices that we don't know of that are the law, which the report brought out in highlighting. So that was one way, like that's how I mentioned that it was one of the ways of taking care of the UCC. However, if the UCC is to take a route like this, which if the Law Commission takes this route, it should be very careful that the practices it is selecting, they are not perpetuating any form of stereotype on what ideally a man should do or what ideally a woman should do. It should be in tune with the realities of today, where both sexes are equally empowered, both of them want to work. We shouldn't be stereotyping a particular sex in a gender in terms of what they're supposed to do, what they're not supposed to do. Unfortunately, though, if the past is an indicator, my hope is quite bleak, because in our country's history, whenever we've tried to come up with a progressive reform, religious reform for giving women equality, the society has always created roadblocks, and this goes back to pre-independence. So, for instance, in 1937, when we had the Hindu Women's Right to Property Act, which was being discussed, and that gave women the right to inherit property under the undivided family, and also removed the disqualification of widows from inheriting. And there was so much opposition from the conservative quarters against it because they didn't want women to have that right. Similarly, in 1941, during the deliberations of the Rao Committee, which formed the basis of the Hindu Code Bill, which was headed by Sir B.N. Rao, who's, like I call him, the forgotten architect of our constitution. At that time, they had argued for giving women more rights, but there were people who warned Women's Association who were supporting it that women were incapable of managing property, and this is a member of parliament talking. And in fact, a Hindu lawyer had famously remarked that every nation has its own character. India can't have a Shakespeare, and England can't have a Kalidas. So, what is this necessity of Europeanization of Hindu law? So, whenever we've tried to bring reform, it has been looked at as Europeanization. And even when the Hindu Code Bill was brought, which was drafted, and Prime Minister Nehru had very clearly said, Ambedkar had very clearly said that it's being brought to give gender equality. That law had to be really toned down. If you read the original Hindu Code Bill to what we have today, it had to be really toned down because the conservative quarters were just not willing to pass it. So that's why that's my concern. If you actually bring a truly code that is truly equal and egalitarian, all quarters should come together and support it in the parliament. It shouldn't be something that, oh, you're touching our religion, so we don't want reform altogether. So my hope is that history is not repeated when it comes to how our past has been when it comes to gender justice. Because imagine after a constitution, it took us till 2005 to consider women as co-pastors and the fact that they can be so it took 55 years to get there when they originally wanted it a very long back. So that's my only concern, that I hope it's actually pushed through, because if you test it solely on the constitution, all these practices should be unconstitutional. Because any form of perpetuation of stereotype or inequality is totally against what the Constitution stands for.
No, this actually, it's quite interesting because it also reminded me. So in my junior college, I was a sociology student, and we went on this field trip to this tiny tribal village outside of Mumbai, where this suddenly came back to me, where how a marriage would take place is that if a man liked like a particular woman and wanted her to be his wife, all he had to do was pick up a matka and walk into a house, and she would become his wife. So in terms of,
surprising.
It is very but that was recognized because it was like an old tribal practice that continued. But my first question was, how can this be legal? Like this is not, because this is back when I was 16, and the first question was, how can this be legal? And I did not really understand many complexities of how religious freedoms work back then. But I think that's one of the many reasons why I got pushed into understanding more about laws. But it's quite interesting to know how if you look for a totally egalitarian and structure that's equal to both genders, it may or may not be. I don't know. I think we have to wait to see how it would be, how people would respond to it. And I also want to touch upon one more thing that you mentioned about how the public consultation process is currently happening right now. Could you share a little bit of your thoughts? Because from what we're reading right now, the Law Commission has received over 8.5 lakh responses from citizens all over the country, and it's still open for another period of 12 or 13 days, and they're expecting more to come in the next couple of weeks. So what do you think about the consultation process, and what is it that people need to know while giving their feedback to the Law Commission as well? If you can just touch upon these two issues.
I think the one thing Law Commission has to really be very clear on, that right now people have a presumption that the UCC is going to come and we are going to impose laws of one particular religion to everybody else. So the Law Commission has to really work hard to dispel that. I think that's the first thing they need to do. And they've used the plank of gender justice. I hope they stick to that. But coming to the consultation bit in particular, I'll discuss some principles that I think should guide consultation and why I think they're not being applied with the current Law Commission. So the first thing that the Law Commission and the government in general, both of them need to do is they need to develop political will. And what I mean by that is that when they say that their consultation should be very real. And it should not be just a facade that, listen, we've done consultation and they have a pre-decided agenda and they're just using the sham of consultation. And second is, before they do that consultation, ideally what they should have done was they should have ensured a level of civic education with people. Like people like you and I, we are still figuring out what the UCC is. Imagine people who are not lawyers, who are not well versed with the UCC. Before the public, you can expect the public to elicit and submit their responses. You should have undertaken efforts to educate them about why this reform is needed, why we are trying to bring a reform, what are we trying to reform. There is so much lack of clarity over what is it that they're trying to reform. They've just said, send us your thoughts on the UCC. That's a very open-ended question. No wonder they've received like lakhs of views. Right now, the debate is very emotional. It's very communal without any substance of why these reforms are needed. So when this came out, you would have seen all news channels and everybody was guns blazing about what UCC is, both for and against. But if you ask a common person on the street, how do you want your law to govern you? They have no awareness about what is happening and why it's needed. So I think the commission and the government what they should have done first, or maybe they can do in the next stage, is educate the people first on why these reforms are needed, because only then when they give you the feedback, you'll get the real feedback, because right now it's a very exclusionary process. Only people who are educated, only people who form a part of a certain circle are able to understand the history of the UCC, how UCC has evolved. Only they will be submitting a response. But that 7 lakh or whatever number they've got is 0.1% of how actually the people will be governed by it. You don't need just the views of people who know the history of UCC. Everybody who's affected by it should submit their response. Which is why I think that civic education first is a process that should have predated or taken before they elicited any responses. Second is, I think it's very important for the Law Commission to be inclusive and participatory. What I mean by that is that the consultation that they're undertaking should be accessible for everyone. Now, what they have done is that they have just issued something on the internet. And people who are accustomed to going to a website, clicking on a link, reading it, only those will be able to access what's happening, which is a minuscule population of the people living in the country. So the responses, again, you will be getting will be a very minuscule people telling what the law on the entire nation should be. So that's why what they should do is they should design the consultation program in a manner that they're also able to reach out to people, let's say, who are belonging to different segments of the society, who are belonging to marginalized groups, who must not have access to these facilities. We are assuming that everybody in India has access to an internet and can go on a link, submit their suggestions, and do all of that, which is preposterous, because that's far from reality. That is not true. So to give you an example, another way of accommodation. So in Kenya, what had happened was that when they were discussing the reforms of their constitution, they had taken into account every possible community in the country. So for the visually impaired community, they ensured that consultation paper was issued in Braille so that even they can access it.
Lovely.
And those materials were provided accordingly. So those kinds of modifications need to be made to reach every segment of your society, not just one strata that you're hoping to achieve. Similarly, the program should also consider factors like poverty, illiteracy, cultural bias, language bias. The program is issued in English. English is not, unlike what people believe, it's not our national language. It's just an official language, but we have so many diverse languages in the country, and that questionnaires that they've asked for has not been translated in different languages. It should be open for people to submit their suggestions in different languages. Somebody might not know English, but they still are very concerned with how their marriage or their divorce or their succession will be governed. So I think all of that needs to be taken into account when they're doing succession, when they're doing consultation in the first place. And I think Law Commission has not done that effectively. And one of the biggest challenges, I think, which is there, is they've given a 30-day deadline. In a diverse country like India, I doubt anybody would be able to come up with suggestions on 30 days, because you're presupposing they already know what to say. So I think 30 days is a very minuscule period that they've given. It's a very less period for people to actually submit, reforms. And I think the second last thing they need to do is they need to promote consensus amongst people. So for instance, how they can do that is if you give adequate time for consultation, so people can also consult amongst themselves. When we do consultations like what you and I are doing right now, people are joining in. They are finding out different viewpoints, and then they are forming a view, and then they are telling the law commission that, listen, this is what we should do. Right now, it's a very unitary exercise that everybody is throwing information on the law commission, and the law commission is deciding what they are going to recommend. So
Yeah.
that's why that consensus is very important, and it cannot be reached in just 30 days. And lastly, what they can do to develop public trust, because the UCC will only be accepted by the people if they feel that it's made through a transparent process, is keeping their proceedings very transparent. Like, people should be able to know what is happening, when is it happening, what is the next step that is being taken. And there are examples around the world where excellent consultation programs have been designed. So for instance, the Scottish government has something called We Asked, You Said, We Did on their website, where you can trace everything that has happened from the start to finish. So if I've given a suggestion, what has been acted on in the suggestion, what reform has been made, what is the stage that it is in. Similarly, in Kenya, what had happened when they were debating their laws, reforming their constitution, they catalogued every response they got. And one day what happened, this man went to the commissioner and said, listen, I gave my suggestions for the constitution. I don't think you've acted on my suggestion. So the commissioner said, fine, what we'll do is, he took the person's name, took them to the database. They had a list of everybody by region, name, what suggestion they had given, and whether it's been considered or not. So their process was very transparent, which is why people had more faith that they have undertaken a very good consultation program. And I think if we look at our history, we have an example. The Hindu Code Bill, irrespective of people's disagreement over whether it was needed or not, was an excellent example of how consultation should happen, because it took care of consultation pre the lawmaking and post the lawmaking. To give you an example, like I mentioned, the Hindu Code Bill was inspired by the Rao Committee report. Now, when the Rao Committee report was deliberating it, it toured all over India. It met people from every city, educated them about what the law was proposing to do, shared questionnaires with them. Questionnaires were printed in the newspaper, free of cost, printed in different regional languages so that people who don't know English or Hindi can also have a look at it. Booklets were distributed free of cost. All of that was done on a very large scale. So somebody who is in today's day and age, who's somebody who's not well versed with the internet, or somebody who's not invested in politics as much, also was given a free copy and said, read this, think about let us know what you think about it, because it's going to affect you significantly. Similarly, when the code bill was brought in the parliament, at that time, there was a significant debate and discussion, and rarely it happens, it has happened in the last 20 or 30 years, there was a clause by clause reading of the bill. So every clause of the bill was read in the parliament and debated in the parliament. And wherever the government felt it had gone wrong, it conceded, it changed that clause, it took that into account. And in fact, I think the bill was also sent to standing committee. I think that's how you design a consultation program. You've educated people, you've taken their views into account, you've used the parliament for what it is supposed to be for every clause by clause discussion, and then the law came about. So I think that's how they should have ideally, that's the broader roadmap that they should take. And the law commission should focus on the first bit, that you educate people and then you get their views. Because right now it will be very uninformed, emotionally charged view, which you're getting, which is not how it should be.
Very
Sorry,
true.
that was a very long answer.
No, it absolutely makes sense. And it's good to know that there is an example of an effective consultation process within our country itself. Like, you have the Hindu Code Bill that went through so many phases. And given that there is precedent, I mean, that's something, it's not a harder ask. That's one good thing to know.
Absolutely.
So that's really great. And I think that was the last of my questions. There's one question that came in. If legislated, what could be effects on entities like families HUFs? I'm guessing this is Hindu undivided families, right? And if it be extended to other communities, and any possible economic implications? I think this is a very loaded question.
To be very honest, Hindu undivided family was historically brought in for tax purposes. Like, it was introduced because they realized that in as per Hindu law and Hindu customs, families were working together. Their family and businesses were so intertwined that it was brought together just to give them tax benefits. That's the only reason why HUF came. It's not something that is, as per my knowledge, it's not something that's rooted in our customs or something like that. That's why it came about. But subsequently, there have been multiple judicial decisions, there have been multiple reports that have called for abolishing it, because A, it doesn't fit with today's time, and second, because it's being misused a lot. People are using it to avoid tax, people are using it for ulterior motives. So if existing jurisprudence is to be taken into account, there are calls to actually abolish it rather than extend it to other families, because you can get those benefits under different laws as well. That's the only purpose that HUF was serving, was tax purposes, and because the property stays in the family because a big family is doing a business or something like that. But that can be taken care of through other laws on succession. So I'm not, I know it'll upset a lot of people if it goes, but if we had to take into account the jurisprudence that has existed for several years, it's unlikely that it'll be retained. But again, this is all speculative, like I said. Yeah, because we
So,
don't
yeah,
know what the text is. Yeah,
even the slightest idea, like
yeah,
from the commission on what they're actually looking for. So
yeah,
it's but I'm really glad that even though like it's not a very detailed exercise, there is still one step in terms in terms of knowing what the people are thinking about. Although this could, as you pointed out, that this process could have been done more efficiently to
yeah.
account for this. But I'm glad that there is a step in the right direction and they can be nudged towards a more effective strategy in the coming years. So, on a final note, for those who are watching, I hope this conversation has helped you understand the concept a little better and may help you giving in a much more detailed and nuanced feedback to the Law Commission. For sharing your feedback, you can log on to the Civis website and leave your feedback under the Uniform Civil Code, or you could go on to the link that the Law Commission has provided in their press note, either which is applicable, and you can give your feedback till the 13th of July. Uh, Thank you so much for coming on, Swapnil, and giving us such detailed uh,
No, no,
giving us such detailed explanation into the history and what it really means. It,
no. Thank you so much for having me, and all the people who had commented. I'm sorry in the middle of it. Nikhil, thank you so much. I did note everybody who was saying hi and stuff. The only parting words that I would have is please submit your suggestions, but make sure they're very informed suggestions, because the entire process of lawmaking, it needs to involve people. We can't just expect people who are in the parliament to think and make laws for us if you don't give them adequate suggestions. So make sure your views are very informed. You know what the law is, you know what it should be, and it shouldn't be charged on grounds that are not tenable. Like, it shouldn't be to promote patriarchy or promote a religion over the other or something like that. It should be very informed views. And I think that's why organizations like Civis are very important, because they're doing that engagement for you. And there are more sources, so read more, then form an opinion and then submit it. But thanks again, Shinatra. Thank you so much for having me. It was lovely speaking to you, and I hope I could be of help with all the questions.
Thank you. Thank you so much.
Yeah. Thank you so much. Bye bye.